Hi, in this tutorial I will cover CCSP domain 6 containing the legal, risk and compliances. Please subscribe to the channel for the regular video updates. Security talks about the protecting the data where the laws and regulations that applies to your data are largely impacted by where the data travels and resides. All in all, for example, the US data centers must adhere to the US laws and applicable state laws, and here the German data centers must adhere to the German laws. That's pretty straightforward, but it becomes tricky when it comes to the cloud technology. When the data moves from one region to another, for example, the US data moves to the Germany, to Singapore, to India, for example, the legal requirements are different in every country, and that impacts in the cloud technology, and will initiate the conflicting the international regulations and laws. When your organization owns and manages the data centers, you have complete control on the infrastructure and the data. It is easy to manage the regulatory and contractual requirements, but when you move to the cloud, the several things remains out of control. But do not forget, the data still remains accountable to meet obligations, and here the CSP is contractually obligated to the customer or to support the customer. There are different legal risks in the cloud computing. For example, the jurisdiction and the governing laws here. The laws and regulations of the customer's home country gets the final say when there are disputes or any conflicts or that arise. There are some cloud service providers that accepts to modify the legal contracts, and some are not. Hence, this remains as a risk. It is important to focus in this area when you discuss the contractual requirements with the CSPs. Data location. It is expected the data to be dispersed across the locations in the cloud unless it is explicitly requested. It should be handled through the contracts. Security and privacy. It is better to ensure that your CSP agrees to meet the independent third-party security standards, for example, ISO 27001. If you are required to maintain the HIPAA, PCI DSS, or similar regulations, then make sure that you choose a cloud provider that can demonstrate the required compliances. Data breaches. Many countries and most US states that have the data breach disclosure laws that requires a cloud provider to inform the customers when their data has been compromised. The customer should seek to have the timings and the methods for the communication, such as breaches specifically outlined in their service level agreements and the cloud contracts. Intellectual property and the data ownership, the copyright, trademarks, and the other intellectual property laws differ from one country to another. The intellectual property and the data ownership risk can be limited through the proactive contractual agreements of the important requirements. But if you really need these to be ensured, this has to be discussed, this has to be incorporated in the contractual agreement. By default, these are not considered by any of the cloud service provider. Legal frameworks. Legal security frameworks. This is based on the NIST framework. There is a link given below in this tutorial to the NIST security framework. So, what are the things here? First of all, we need to identify this focused on understanding that your organization's assets, its systems, data, people, process, and capabilities. So, this need to be identified first of all. Then we have protect. The goal of this control in this function is to limit or contain the impact of the potential security threats and keep your system functioning. Then the detect. This function includes the set of controls, and activities required to discovery of the security events and incidents in the timely fashion. And then we have to, after the detection of those events and incidents, we need to respond to those events and incidents. This function deals with the taking appropriate action against those detected security events and the incidents. Then we have the recovery. This function will focus on maintaining the organizational resilience and restoring all the functionality after a security related incident. In eDiscovery, here we have identification, preservation, collection, review, and analysis in production. So, what is e-discovery? This is also known as the electronic discovery. This is the process of the electronic data being collected, secured, and analyzed as part of the civil or any criminal legal cases. They need to collect, they need to identify, locate, and tag the potential relevant digital evidences based on the details of the e-discovery request or the order. Then we have the preservation. Place the potential relevant digital evidence in the legal hold and ensure that it cannot be modified or destroyed. The preservation ensures the integrity of the data which is being collected to be presented in the court. Then collection, gather all the potential relevant digital evidences and prepare for review, process, and analysis. Review and analysis. This step is where your legal counsel typically gets involved with the digital evidences and as they evaluate what you have collected for the relevance, completion, and the context before it is produced. Then production, the digital evidence is delivered to the external party, such as the opposing counsel or requesting authority in the agreed upon format and via the agreed upon means, so that it is the chain of custody is maintained throughout. Remember, when you receive an e-discovery request order, maybe you immediately you should involve the legal team and understand which laws are applied for which the data is requested. There are standards on the e-discovery uh, which talks about the data collection and the e-discovery. So we have ISO 27050 and we have CSA guidelines as well. Um, this is CSA. So for CSA guidance on e-discovery, you can find another video in the description of this video below. Then we have the forensic requirements. The digital forensics is the collection of the tools and processes that supports the actual collection of the evidences as requested in the e-discovery order. It is difficult in the cloud environment to collect any evidence, but the customer don't have access to all the assets, and the cloud service provider may deny the to provide information which is not required by a court, but you need that for the investigation purpose. So it is difficult here. So just remember one thing, that the CSP may deny to your additional request if it is not directly coming through the court order, because customer do not have access to all the assets, so they need to rely on the CSPs there. Privacy issues. Privacy is limiting access to the personal information to authorized parties for the authorized usage. We have CIA triad. In the CIA triad, we have confidentiality, integrity, and availability, but there is a missing lag here, the privacy. It is always missing. It it complements the confidentiality, integrity, and availability, but at its own beast that deserves the individual attention, especially. Now, the data like PII is subject to the combination of the contractual and the regulatory requirements. Overall, the CSPs must ensure that they have the mature auditing capabilities to effectively monitor and report on their compliances with the privacy requirements. So, in terms of the contractual private data, often the requirements to establish a policy, contracts, who can, in terms of policies, who can access, what could be the usage or forbidden, whether we need to encrypt the data. So these are all contractual private data which are to be used as part of the contract. Failure may lead to the contract penalties, loss of business, or any civil suit. So this is a kind of contractual private data. Then we have the regulated private data. It is protected by the laws and regulations. This kind of data must be protected by the several laws and regulations in different countries. For example, we have HIPAA for PHI, and we have PCI DSS for the payments cards data. In addition to loss of the business, failure to protect any regulated private data can lead to steep financial penalties or even the criminal charges. We have privacy issues. These are There are country specific legislations related to the private data. There are few countries here to discuss. In USA, we have, for example, HIPAA and GLBA. Um, in US, it doesn't have a single federal law that governs the data privacy for all the personal information, but there are multiple federal laws governs the privacy for a specific type of data and specific industries. For example, we have HIPAA. It is for the specific data types and for the specific industry, which is the healthcare. This helps to protect the patient's privacy and regulates the usage and the disclosure of the individual's health-related information. We have GLBA, which is Graham-Leach-Belly Act. This is an US federal law that requires the financial institution to safeguard their customers' PII. In Canada, we have PIPEDA, Personal Information Protection and Electronic Documents Act. This applies to the collection, usage, and the disclosure of the personal information throughout the course of all the commercial activities in the Canada. So PIPEDA requires that the companies protect the personal information using the appropriate security controls such as encryption and passwords. Then we have European Union countries where we have very strong privacy regulation, GDPR, General Data Protection Regulation. So this is applicable for the European Union, and its member countries have some of these, these privacy laws. This is um, this is not just applicable to the union countries, but it is applicable to the countries, all countries whosoever is processing the European residents' data. So it has, the Article 5 in GDPR that lays out 7 principles for processing the personal data. We have, in GDPR, we have, lawfulness, fairness, and transparency. Um, in this, the process says the personal data in accordance with the laws and inform the customers of how their data will be used. Then we have um, the purpose limitation. Um, So in the purpose limitation, the personal data may be processed only for the legitimate purpose. The purpose that you have mentioned to the owner of the data, that this is the purpose I'm collecting your data. Data minimization, collect and process only as much as data is absolutely necessary to provide the agreed upon services. So in data minimization, it is, the minimal agreed services should be used the data for. Accuracy, it is deemed necessary that you need to maintain the data for in the accurate form and up to date. It is the data controller's responsibility. Then we have storage limitation. It requires the data to be stored for just for um, the the services which are required to use this data and for the limited period. Then we have integrity um, and the confidentiality, C and I. So ensure that the security of the personal data and provide the protection against unauthorized access and accidental loss or any kind of destruction. Then we have accountability. In accountability, the data controller or any organization or person that collects the personal data, must be able to demonstrate the compliances with all of these principles that we discussed. When we have Brazil LGPD, General Data Protection Law, this is the model based on European GDPR that is managing the privacy of the Brazilian citizen personal data. Then we have Chinese cyber law. This requires the critical information infrastructure operators. It stores the personal information within the territory of People's Republic of China. Then we have Russian data localization law. This mandates that all the personal data of the Russian citizens must be stored and processed on the systems that are localized within the Russia. Privacy issues, we have seen many privacy regulations from one region to another. Can't we have a common international standard? Probably yes. Um, uh, we can have ISO 27018 that is specific to privacy in the cloud, and then we have the generally accepted privacy principle GAPP, that is broad framework to build the privacy program. So ISO 27018, this assist the CSPs in complying with the contractual and regulatory privacy requirements. This enables the CSPs to be transparent with its customers about how it handles PII, enable in cloud customers to select the CSPs that handles the PII in a manner that fits their needs, assist the CSPs and cloud customers in entering the contractual agreements by providing a clear framework for discussing and handling the privacy concerns. Then we provide the cloud customers with a mechanism for measuring a CSP's compliances with the privacy obligations by requiring, they undergo the periodic independent audits. The GAPP, it has 10 privacy principles. For example, management that defines this defines documents, um, um, management. This defines documents and communicate the privacy policies and procedures to impact the parties and relevant stakeholders. Then we have notice, inform, um, inform the impacted parties of how their PII is collected, handled, and protected. Then we have choice and consent. So, obtain the consent from the impacted parties to collect, use, retain, and disclose their private data. And we have collection. In collection, limit the PII collection to what has been committed to and consented by the impacted parties. Then we have use, retention, um, and the disposal. Limit the PII use to what has been committed to and consented by the impacted parties. Then we have the access. In terms of the access, Um, access all affected parties to access their PII to ensure that it's accurate and up to date. And then we have disclosure. In disclosure to the third parties, disclose PII to third parties only for the purposes identified in the notice and ensure that the impacted parties consent to this disclosure. Security for the privacy, security to the for the privacy, ensure that the confidentiality of the PII through the usage of logical and physical security controls. Then we have quality, maintain the integrity, accuracy, completeness of PII for the purposes identified in the notice, and keep monitoring keep monitoring audit system processes to ensure that the privacy and policies and procedures are effective. Ensure that there are means to find, report, and remediate the privacy gaps. We also have GDPR as a common one, which is being taken as a reference in the several countries, but it is very specific to the European countries. Audit process, methodologies, and required adaptations for the cloud environment. We have, internal and external audit controls. Remember, any application that stores or processes the sensitive data should be subject to both internal and external audits. External audits are performed by the independent third party who provides the regulators assurance that the CSP is meeting all the security obligations. And the company should perform the regular internal audits to avoid the huge gap in the external audit. So before you go for the external audit, which is done by the independent third party, just go before that for the regular internal audit so that there are no huge gaps. Impact of the audit requirements. Many audit requirements says to audit the data centers physically, but in cloud it is not possible for non reasons, right? Because of the physically dispersed data centers. You may know that if you are processing the data in one region, your data centers holding the physical servers and all, maybe in the different country. The shared responsibility between the CSP and the customer requires that all parties fully understand their security responsibilities and properly prepare for their specific audit requirements. There are some challenges of the virtual and the cloud which need to be identified. So auditing the cloud environment has massive challenge because of the VMs, virtual machines, and the other virtual technologies. There are the massive infrastructure is spread across the world in the different data centers. It is not possible to audit every location. So here the sampling may help to randomly select a subsystem, but it doesn't work with the virtualization. And the auditor need to be able to audit the virtualization architecture of the cloud service provider. Also, sharing the information is another challenge, but with the external auditor, it can be done under the NDA, the non-disclosure agreement. The audit reports. So, what is the audit report? This is an artifact that describes the findings from an audit and explain the auditor's opinion of the system that was examined. So we have the different reporting system here. SSA 18 statement on standards for the attestation engagements. This was, this reporting was upgraded from SAS 70 to SSA 18. Then we have the service organization control, SOC. There are three types of SOC reports. SOC 1, this report is financial focused. For example, if you are providing the payroll processing services, the SOC 1 may be required to do the business. SOC 2 report is typically requested when you are hosting or processing any other type of information for a client. For SOC 1 and SOC 2, both are having further type 1 and type 2 report. The type 1 report focused on the service organizations systems, and whether the suitability and the design of the specified control meets the relevant trusted criteria. While the type 2 report, this includes the type 1 and also measures the operational effectiveness of the specified control, whether these controls are effective or not. And the SOC 2 is having different principles here. We have these principles. There are five principles for SOC 2: the security, availability, integrity, confidentiality, and the privacy. So there are five principles associated with SOC 2 report when we work on that in terms of the technical security control. So we need to consider all these five principles when we apply or decide on the controls. SOC 3 is related to the report which is less formal in appearance than SOC 2 report and are better suited for the public marketing material for a website or white paper kind of things. Audit process methodologies and what is required for the adaptations for a cloud environment. The gap analysis, it is the comparison of the actual results and with the desired results, performed at the end of an audit. The reports deviations, this reports the deviations, what was required as per the law, regulations, and what is discovered. And based on that, we analyze and we identify those gaps. Audit planning, it has different steps when we plan the audit. So need to define the objectives, need to define the objectives of the audit, document the goals, format, desired output, roles and responsibilities of people who are involved, who are supposed to involved in the audit, what will be the process of the audit, and then we move to the audit scope. Okay, so as part of the audit scope, we need to understand the previous audits and findings. We need to consider those. We need to identify the criteria. This needs to be included, the time duration, the communication, physical location, what all physical locations are supposed to be included in this audit as part of this scope, what is included, what is excluded, and what will be reported. So all these things are supposed to be in this scope. Then we perform the audit. So as part of this, during the audit, we remain in line with the audit objectives. We do, just remember that during the audit, it is not. It is very important to focus on the scope and the identified objectives, scope, assumptions, and the schedule. And then we have the review of the results of your audit and identify the lesson learned. So as part of the review process of your audit and identify the lesson learned, all the lesson learning must be documented for the future improvements, and based on the review, we need to continuously improve in terms of the audit process. ISMS, this is based on ISO 27001. It is a set of based on a set of policies, procedures, and systems for the systematically managing the security of an information system like a cloud service offering. The main objective of ISMS are to manage the risk to the organizational and the customer data, ensure the business continuity, and protect the organization's reputation. The key pillars are people, process, and technology as part of the ISMS. Then we have the policies. So, what is the policy? Policy is a formal document, a desired or the required standard for a system or an organization. Basically, what it communicates the management's intent. There are different policy types. One is the organizational policies. So these kind of policies are focused on the code of ethics, acceptable use of policy, vacations, etc. Then we have functional policy. This is focused on guiding principles to have controls related to the the information technology. For example, access to the IT resources, physical security, access to the office, incident response, backup and restore of the critical data or critical material, sensitive material, email accounts, passwords, disaster recovery, BYOD policies. BYOD is bring your own device. So when can you use your own device for office purpose? When cannot be? So all of these are functional policies which considers related to the information technology. Cloud computing, this is the CSP's policies around the encryption, data retention, etc. So this is related to that. Then we have the involvement of the relevant stakeholders. All kind of security and the compliance is related discussions should include all the stakeholders like compliance, risk management, legal, IT, operations, and information security team. So all of these relevant stakeholders should be involved, should be included for in the audit process when we try to identify the methodologies and what needs to be adapted. So all of these all of these stakeholders must be involved in the process. What are the implications of the cloud to ERM, enterprise risk management? So first of all, when we try to assess the cloud service provider, we always need to assess their risk management programs, how they are managing their risk, and how frequently they are monitoring, how they are maintaining the risk registers for their data centers, for the deployments, etc. Need to consider that. A data owner or controller versus a data custodian. So this is a very important topic from the exam point of view, and this is at times this becomes very confusing for the candidates, the aspiring candidates for CCSP. These terms are coming from the GDPR primarily, like the data controller and the data processor. Primarily these terms were defined in the GDPR. So who is the data owner? First of all, the data owner is, we can say, the data controller, because for example, you have the customer in the cloud and you have the provider. So you collect the data as a customer, as a cloud customer. You collect the data from your customers, and for the processing purpose, to perform the business or to provide the services. And on behalf of the cloud customer, the cloud provider is processing that data or storing that data. So the cloud provider there, it becomes the data custodian or the data processor. Okay, so the data owner is an individual who holds the responsibility for dictating how and why the data is used, as well as the determining how the data must be secured. The data owner processes the data using its own processes. The data owner may outsource that to a third party. Even when outsourcing happens, the data owner doesn't lose control of that data or associated responsibilities, no matter who process the data. But data owner always responsible for specifying how the data is used, processed, and secured, and always remain liable or accountable for any breaches or so, even though the data is being processed or being stored by the cloud provider. But even in that case, the data owner or the data controller, or we can say the cloud customer, remains responsible, accountable for any breaches or any kind of liabilities. The data custodian here, or the data processor, we can say, or in terms of the cloud, it is the cloud provider who can be the data custodian or the data processor. This is an individual who can process the data on behalf of the data owner. The data custodian remains responsible for adhering to the data owner's established requirements for using and securing the data. So remember one thing: the data owner can define the security policies, can define the security controls, but the data custodian remains responsible to apply those controls. There is a thin line between both. Defining the security controls and applying the security controls. So defining is responsibility of the data owner, and applying those security controls remains the responsibility of the data custodian. The regulatory transparency requirement. This is the regulation or the regulatory requirements remains the shared responsibility between the data owner and the data processor. The cloud service providers must share the risk information. Otherwise, the customer kept in dark about their own risk and for which they are responsible for or accountable for. The regulations like GDPR and SOX includes the requirements for the cloud service providers to share the relevant security and the risk information. Also, under some regulations like HIPAA, GDPR, a cloud provider is formally required to notify all the impacted customers in case the breach is discovered. But there has to be some kind of regulatory requirement contract. So these things should be discussed and agreed during the contract finalization. Risk tolerance in terms of the risk management. So, what is the risk tolerance? It is a risk appetite, we can say. It is a level of risk that any organization is willing to accept in its course of business. The high risk appetite means your organization is prepared to accept a large amount of risk in favor of the cost saving, or maybe there may be other factors. Low risk appetite organizations are having conservative approach to the risk management. So once we are done with the risk tolerance, once we set the risk appetite for an organization, we conduct the regular risk assessment and the monitoring of your risk profile. Here, what is the risk profile? Risk profile is an analysis of the existing threats to our business, which poses an organization and its assets. So, for the risk treatment, for risk assessment, we need to identify all the critical assets. We may take help from the BIA. When we do the risk assessment, we need to identify all the assets and to how to identify whether the asset is critical or not. When to label that this is critical, what is critical, what is non-critical. We need to perform the BIA. So BIA is the business impact analysis. We perform the business impact analysis to identify the criticity of these of the assets. So coming back to the risk assessment, we need to identify all the assets. Then we need to analyze the risks related to those assets. What is the likelihood? How frequently it can happen? What kind of expertise it requires? What is the impact which may have? And then evaluate. Compare the analysis with the risk tolerance and profile. And based on that, we treat the risk, whether we can avoid, transfer, mitigate, and accept. So avoid means we can avoid the risk. Or we can avoid, for example, if we have a risk in the business, we can avoid doing the business, which might not be the case. So we need to maybe choose a different treatment. We may transfer some risk to the insurance companies, to the cyber insurance. We can add some more security controls to mitigate that risk, or probably we knows that this could be very minimal, and we knows that okay, this is not going to impact us much, so we can accept that risk as it is. There are few risk frameworks, different risk frameworks, ISO 31000, NIST, and ENISA, European Network and Information Security Agency. So these are the few risk frameworks which can be used. There are different terminologies here to specific risk metrics. One is the inherent risk and the residual risk. What is inherent risk? This is a level of risk that exists prior to any action being taken. It is the worst case scenario that a risk poses. For example, to describe this risk, anytime you leave your home, you are taking the risk of being hurt by a texting teenage driver, your neighborhood's dog, or a falling piano. Um, the likelihood of each of these risks probably varies from the moderate to low, but it's an inherent risk is there. Similarly, the residual risk is a level of risk which is remaining after we take some preventive measures. Um, we have a risk and we try to mitigate the risk, but even after applying some security controls to mitigate those, we have some residual risk, some leftovers, some remaining risk. So this is known as the residual risk. Outsourcing and cloud contract design, we have during the outsourcing of the SLA, during the outsourcing of the data center, data storage, hosting, etc., it is important to capture the responsibilities in the contract to have clear accountability and responsibilities. In the cloud, the companies lose some of that control and must figure out how to address this in their cloud contract. Also, the companies must understand their business requirements and the potential contractual implications of outsourcing to the cloud. As with the contracts, your cloud contract should include various SLAs that codify the expectations around your business requirements, things like your system availability, performance, response time, and minimum level of security should be identified as part of your SLAs. Most important is the SLA should also identify the penalties on the CSPs for any non-compliance or failure to meet the agreed upon SLA. What is SLA? So SLA is a contract signed between the customer and CSP, the cloud service provider, stating the guaranteed service being offered. If fails, then it may attract some financial penalties. So, for example, some aspects which should be covered as part of the SLA, we have uptime guarantee, SLA penalties, what should be the SLA penalty exclusion, what should be the excluded things, suspension of the service, provider liabilities, data protection requirements, disaster recovery, security recommendations, etc. So, these are the things which should be part of the SLAs. The master service agreement, it includes the maximum possible terms and conditions, speed up the agreement process. In the future, you won't need to renegotiate the deal and focus on the project details instead. So this is a masterpiece where you do not need to renegotiate for anything. It covers most of things at a very high level. For example, some service overviews, payment terms. You don't need to review that again and again. Audit requirements, product warranties, dispute resolution process, etc. So this is the master service agreement. Then we have SAW, a statement of work. This is the contract between a client and an agency that includes the specifics of each product and the services to be delivered. It usually works as a project management and sets the expectations. The parties often sign SAW along with the MSA. For example, there are few examples of statement of work. For example, the project overview, what will be the project stages, what are the deliverables as part of this statement of work, what will be the project deadlines, what will be the project cost, etc. Then we have vendor management. It is a process by which an organization manages the risk related to the vendors and ensures the effective service delivery by that vendor. There are a few considerations for the vendor management. For example, the contract negotiation, SLA monitoring, communication. So, what is the contract negotiation? You understand the business requirement, cloud strategy, and the risk profile. Hence, we advise the management on SLA uptime, availability, and the compliances, etc. So that is the thing that we need to understand and we need to advise to our management in terms of the contract negotiation. So remember that you are the power during the negotiation, during the contract discussion. But after that, you are no more in the picture. SLA monitor your cloud vendors' compliances with the agreed upon SLAs and communicate your point of contact on the cloud provider side. Communicate effectively their needs and requirements to your vendor. Then we have the contract management. So it is a process of managing some contract negotiation, creation, and execution to reduce the risk and maximizing them. There are different things here, like the definition. The contract should clearly define the terms on which are understood and agreed by provider and customer. Then we have metrics will be used to measure the vendor's performance and fulfillment of the contract and SLAs. Access to data. The contract should include the um, methods and requirements related to your accessing your data in the cloud. Performance, this includes the agreed upon performance requirements about the availability and response time. Then security, it is a specific security requirement that should be included in the contract, referring to the technical requirements, for example, the data encryption. That is the security requirement. Right to audit. The right to audit clause in the cloud contract, granting permission to personally inspect a cloud provider's processes and data centers upon request. Litigation. Provider and customer should know the responsibility in each in case any of these faces the legal action. So need to understand their responsibilities in that aspect. And then we have the termination. So as part of the termination, this need to define the terms clearly under which the contract may be terminated by either the provider or the cloud customer. Supply chain management, looking beyond your own technologies and evaluating the security and compliances of the technologies to review and analyze for risk to understand what may risk to the organization in order to continue with the supply chain. So you need to understand that to manage the supply chain. With this, we conclude the CCSP Domain 6. Thank you for watching. I hope you like the content in this tutorial. Please tell me in the comment section. Your colleagues may also need this while they are preparing for the CCSP exam. I would recommend to just watch these videos before going for the exam. This will help you to revise and to prepare for the exam. Please subscribe to the channel for the regular video updates. Thank you.